How to stop a summons or the other attorney using Trinsey versus Pagliaro. Now, one way to stop hearsay evidence from being submitted by an opposing party's summons or attorney is to be aware of the significance of the Trinsey versus Pagliaro case. It can affect many things, and it can probably get you a win if you're paying close attention to what the other guy is doing. Believe it or not, they're not all geniuses, and they do make mistakes. And if you can catch them on the simplest of mistakes, you can win your case, especially if they're coming after you for some sort of criminal matter. That's really what this is about. That'd be a ticket or any other form of criminal matter. So when we look at Trinsey versus Pagliaro, it's plain to see that the courts rely solely on the affidavit sworn by the process server, who serves the court documents to the summons us to the court. Now, without that being valid, there is no case. There is no jurisdiction established. Guys, if you just focus on how to break the link of jurisdiction throughout your case, that will be the key to winning. Now, whether you can stop them from bringing you in personally, or whether you can break them down on their procedures, you need to use all those forms of ammunition to break down the fact that they have no jurisdiction, and then you can motion for dismissal. Remember the maxim that an unrebutted affidavit becomes the judgment in law. That's the whole trick they're playing on you. So if we don't rebut the affidavit of the process server, well, then we're essentially having a judgment awarded against us before we even get started. So the first major step when we get summoned is to respond right away to the summons or subpoena that the process server brought to appear and swear to the truth on his affidavit. Then if you weren't served properly, then you can order the case dismissed. So the definition of a summons is an instrument used to commence a civil action or special proceeding, and it's a means of acquiring jurisdiction over a party. Now, if you only learn one thing in law, to focus on how not to let the other party acquire jurisdiction over you, which, by the way, is a voluntary act, well, then you can learn how to avoid many of the kinds of cases that are brought against you. It's all a trick to get you to volunteer and walk in. Same with the subpoena. It looks like a command to appear at a certain time to give testimony upon a certain matter. But again, it's got to be valid. So, May 28, 1964, John S. Trinsey Jr. versus Frank Pagliaro and the Albert Foreman, Esquire, the defendant's motion to dismiss for failure to state a claim unsupported by affidavits or depositions is incomplete because it requests the court to consider facts outside the record, which has not been presented in the form required by the rules 12b6 and 56c. And the statement you want to sort of memorize if you get anything out of this video is statements of counsel in their briefs or arguments, while enlightening to the court, are not sufficient for purposes of granting a motion to dismiss or summary judgment. In other words, they can't get a summary judgment against you if their briefs are not sufficient. And almost everything you should know that comes into the court these days is hearsay. There's typically not even a witness with an affidavit attached swearing that they were harmed by you. And if they weren't, the rules of common law prevail if you bring it up. If you walk right in, continue like it's the real deal, and it binds you and it obligates you to do something, well then you therefore agreed. Okay, so you got to be careful. This is how you avoid volunteering. And this Trinsey versus Pagliaro concept is very important to get. So let's look at the summons. If the summons, if the party, for example, if the party delivering the summons will not come in and testify that they could verify it was in fact you they delivered it to, that could be a flaw. See, if you learn how to identify flaws, you can win cases. And frankly, in most cases, they can't. Even by the fact that, this is why we teach people to avoid giving their name at the door. Ask questions instead, because until they get the name, they can't deliver it to you. Even then, they can't positively identify you. So if the case proceeds and that party isn't actually there and swearing under testimony that they delivered proper service, you can win the case just on that one issue alone. Forget what their attorney says. Their attorney is going to tell you all kinds of things. They're trained to lie. you have to see first-hand witness, have them come up and testify to that. They typically do not, and that's a big flaw that you can go for. Additionally, the attorney goes on and starts saying all kinds of things. Well, he did this and he did that, and they testify. And if you learn how to object to almost everything that attorney is saying, your chances of winning are much better. If you do happen to lose, the fact that you put all those objections in based upon those points will be the only points you can bring up in an appeal. So later, if you have to appeal something and you lose the case, but you got to appeal, every objection is the key point at which you can bring up in the appeal. You can't bring up other information or new information. You can only bring up your objections and how the court ruled against you and shouldn't have. That's how you win an appeal. So you're always setting up your appeal as you go through a case by objecting to everything, particularly as it relates to hearsay information like the summons. The summons was hearsay. The driver's license that they might bring out is hearsay. There's no way to evidence that that's you. You see how this works? So you don't just buy into everything they present you as being factual. Everything needs to be sworn to. Whether it's a mortgage, a tax bill, a driver's license, whatever they're using as some form of evidence, it's hearsay, and you have to object to it. It's unsupported by affidavits, which means it's incomplete. And if it's incomplete, it's insufficient for giving it can't be used for the purposes of granting a motion to dismiss or a summary judgment. In fact, your motion to dismiss should be they're lacking that affidavit and proper deposition. So how you protect your rights is to protect them early and often. And it's all about the flaws in their procedures. And this is one of the easiest way to win a case or an appeal later, as long as you objected to things. So that's just my tip of the day. Get more information at urlaw.org. If you'd like to see this document or other similar documents, become a premium member at urlaw.org.